My name is Jerome O'Sullivan, and I'm a partner in the Commercial Litigation department at Healys. Clients often raise the possibility of making allegations of fraud in legal proceedings. They assume that an allegation of fraud will greatly increase their prospects of succeeding against their opponents. Thankfully, the range of scenarios to which a fraud claim might apply is far broader than the more common causes of action. However, there are a number of legal and procedural hurdles that a claimant would have to overcome prior to succeeding in such a claim. One potential avenue would be a claim for fraudulent misrepresentation. Such a claim is based on deceit, which is a tort, so it can arise independently of any contractual obligations. To succeed in a claim for fraud, the claimant would need to demonstrate a number of elements. Firstly, that the defendant made a false representation to the claimant. This involves a number of factors, including there must be a false statement of fact issued orally or in writing. The statement could be made by conduct. There was a case involving the Spice Girls pop group in which they issued an advert showing all 5 girls. One of the girls left the group, and the advert was held to be a statement by conduct that none of them intended to leave. Silence will generally not amount to representation, with the following exceptions. Various true representations are made, but there is a material omission in what is left unsaid, or circumstances had changed and the original statement had become untrue. The statement must be one of fact, not an opinion. The claimant must also show that the defendant acted fraudulently. Fraud in a civil case has been defined by the House of Lords in the case of Derry and Peake as a false representation that was made knowingly or without belief in its truth, or reckless as to whether it is true or false. Therefore, the claimant only has to demonstrate that the defendant suspected that the statement might be untrue, but made it anyway without checking its accuracy. The claimant must show that the defendant intended that the claimant should act in reliance on the representation, and that the claimant does act in reliance on the representation and in consequence suffers loss. There are a number of advantages in pleading fraud, including an allegation of fraud can be useful where the contractual matrix is not clear-cut, or where individuals have introduced or facilitated a transaction. An allegation of fraud can be the foundation for a wide range of potential claims, including deceit, conspiracy, bribery, dishonesty, dishonest assistance in breach of trust, and knowing receipt of trust monies. It gives you the possibility of applying for a freezing injunction or a search and seizure order. Importantly, it raises the possibility of lifting the corporate veil. The House of Lords has confirmed in the case of Standard Chartered Bank and Pakistan National Shipping that a notable exception is if a shareholder or director makes a fraudulent misrepresentation. If the defendant company did not have enough assets to meet any likely award, then you could claim against the individual director or shareholder who made the representation. There is no defense of contributory negligence. Reliance or inducement is more readily inferred by the court when fraud has been proven. Any limitation or exclusion clauses would be ineffective in the event of fraud. The scope of damages that a claimant can recover is wider. Unlike in a claim for breach of contract or negligence, there is no requirement that the relevant loss has to be a foreseeable consequence of the fraud. The claimant only has to demonstrate that the damages flowed from the fraud. Compound, as opposed to simple interest, is available in relation to damages. A longer limitation period applies to claims for fraud. Section 32 of the Limitation Act confirms that limitation does not begin to run until the fraud is discovered by the claimant. However, the disadvantages of pleading fraud include the following. There are more exacting rules as to how fraud has to be pleaded, so that the defendant knows precisely the case that he has to meet. A solicitor or barrister is not allowed to plead fraud unless he has clear instructions to make such an allegation and has before him reasonably credible material which establishes a prima facie case of fraud. When deceit is pleaded, the temperature of the case immediately escalates. This leads to parties becoming more entrenched and makes it less likely that the case will settle. Under the civil procedure rules, any third party is entitled to access all statements of case filed with the court as a matter of right. Therefore, there is always a possibility of such allegations reaching the press. A failed claim for fraud is more likely to attract an adverse cost award to be assessed on an indemnity as opposed to a standard basis. It would be unwise to allege fraud against an insured defendant, as success at trial is likely to void the defendant's insurance cover. I hope that you found this talk informative, and if you require advice on this or any other legal issues, please do not hesitate to contact the litigation department of Healys LLP.